It's the state of Texas versus Raymond Peoples. You may call yourself and come forward.
Call myself Dixon.
Yes, sir.
First time I've ever been charged with a crime was when I was 27 years old. And I electrocuted me through the shock box that they got on my leg because they don't want me to talk about the prior cases and why I'm in here and all the stuff that they've been doing to me. And there's so many powerful people in the government that hate my guts, not because of what I did to them, but because of who I am. I'm about to talk about every single factor from the day I was charged with the first illegal crime back in 2016, all the way up into this new crime that he just told me about, of some feces being thrown on somebody. And everything that I'm about to mention is on record, or I have witnesses about. And I'm about to educate the jury about the law that y'all keep breaking, about the rules that y'all keep breaking, and how y'all like to keep trying to manipulate stuff to keep me in here. This is my fourth trial. My fourth trial. And the only time they were able to get a conviction was when it wasn't a jury in front of me. And that conviction came from a probation violation of a charge that they had no jurisdiction over in the first place. It was supposed to be in misdemeanor court, not felony court. During the jury selection 2 days ago, when the transfer...
Buckle up, guys. Today we are going to witness one of the most unusual courtroom testimonies you'll ever see. The defendant immediately turns the spotlight away from the charge itself and instead claims he's the victim of years of government retaliation, insisting this is already his fourth trial. As the tension keeps building, he promises to expose corruption and educate the jury on the law. But before he can go much further, the judge decides it's time to step in and regain control of the courtroom.
But when the lady started transcribing this, she's going to need to... And it was 30 minutes into it. I said, y'all not transcribing this? We're about to.
Hold on, sir. Sir.
What?
Sir, let's get relevant here. You were charged with the first-degree felony of aggravated assault against a public servant. This isn't the time to make a speech of your whole life. Let's stay within the relevant allegation. And don't interrupt the court. How many times have I said that? You have a fair opportunity to be heard. The court is required by law to direct the law to the people. And the jurors are instructed, we are focusing the relevant matters of the accusation in the four corners of this indictment. Let's stay within this. This isn't time for your life story. If you are found guilty, if we go to the punishment phase, there are matters you can bring up that are relevant to punishment. This is only about the allegation. Please stay within the four corners of the charge. Thank you, sir.
The jury, the day I'm talking about is the jury selection for this charge. So
stay within the four corners of the charge in this indictment. That's what's relevant. Thank you for following the rules.
That's what I'm doing. So there was no point in me objecting to what I was seeing on the jury selection paper because he wasn't.
Once again, sir, this is with the four corners of what happened on or about June 6, 2023. Let's don't talk about jury selection. This was all, that's not relevant to the facts. Stay within the facts, sir. Please go forward.
The Sixth Amendment says the accused shall enjoy a speedy public trial by an impartial jury. The word impartial means fair. In the district, whereas the crime shall have been committed, which shall have been previously ascertained by law, shall be confronted by the witnesses against him, which means the witness that's against me shall have said that I did whatever they charged me with. And yesterday, that man sat right here and said, yeah, you scratched me. That's how I got my injury. But yet I am indicted for stabbing him with ink pen. All persons born or neutralized in the United States.
Naturalized, sir.
Naturalized, thanks for correcting me. You're right. Naturalized in the United States. Ooh, you know this. And you know it. Oh,
Sir, just
sorry.
please move forward with what you need to say.
Born or
Thank you.
naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. No state shall make or enforce any law which shall abridge the privileges and immunity of the citizens of the United States. Last I checked, I was born in the United States. Nor shall any state deprive any person of life, liberty, or property without due process. Last I checked, me talking about how unfair a jury is, I had the right to do that because my right is being abridged. So I can tell the world and explain how my rights are being abridged during my testimony in the four corners of the indictment. Is that correct, Judge?
Sir, move forward and stay relevant to what the allegations are in the four corners. And please, for the 20th time, please don't speak over the court when I'm speaking. Sir, how many times have I said that to you? You have a fair opportunity to speak, but it's not on your terms. The law has its rulings. The rules of evidence have its rules, and you, in representing yourself, must follow them, whether you like it or not.
If what I just said was correct or not.
It wasn't relevant to whether the facts are. I give the law. You don't start quoting constitutional law. I'm going to give the law, sir. You just talk about the facts. Please move forward. These people have valuable time here. Let's stay within the rules. Give them what your version of the facts of this incident were. Please move forward. That's what we're here for.
So you above the laws of this country?
From this point forward, the courtroom turns into a constant battle over relevance. The judge repeatedly reminds the defendant that the jury is only there to hear evidence related to the aggravated assault charge, while the defendant insists his constitutional rights and previous legal experiences are directly connected to the case. Instead of describing the alleged incident, he continues arguing legal principles, forcing the judge to interrupt again and again in an effort to keep the trial on track.
I'm just asking
you one more statement like that, and I must hold you in contempt of court. I don't want to do that. I've ordered you to follow the rules. Please follow the rules.
I see how Jesus feels.
That's your statement?
I'm testifying
to the facts of the case, sir.
So you tell me I can't be a character witness to myself?
Sir, give what you want to say to the jury of the facts within the allegations. That's what we're here for.
The jury is sanctioned by law.
I'm sorry, sir. This isn't a debate. Go into the facts of the case, please.
Okay.
I've made a ruling. Follow the ruling.
I'm being a character witness. Can I call myself as a character witness?
You don't do it that way. You can speak.
Can I talk about myself?
Yes, you.
As a character witness?
The character as to character is not relevant at the guilt or innocence phase. It's at the punishment phase. You can talk about what the facts are and what might have been motivations. I'm helping you out on this. You might have been what motivations that you had in acting within the allegations here. I can't tell you what to say, but character evidence is something that is reserved for the punishment phase. That's the law. You should know that.
For the last 2 days, you've been destroying my character.
Well, sir, that's
I can't rebuild it.
You should have objected.
I did object. You told me that didn't make it. I did.
Okay, move forward. Move forward, sir.
I would like to object to the jury selection.
Overruled. Go to the facts of the case, sir.
But I need to.
Sir, it's overruled.
Before you.
Sir, it's overruled.
Okay.
You move forward and we'll take it.
On record.
I'm sorry, sir. We'll take that up outside the presence of the jury and you'll have a fair opportunity to make your statement and put the rule on, but not in front of the jury. That's not what's relevant for them. They need to know what the facts are, not what your personal feelings are about this court. Move forward.
That's not the way.
Move forward, sir.
I have to tell you what my objection is before.
No, I will do it outside the jury. We'll do it outside the presence of the jury. That's not relevant.
They can do it at the jury selection.
No, sir. No, sir, that's not the proper way to do it.
That is
We're going to follow.
appropriate way, Your Honor.
I've made my ruling.
All my family that is watching this right now, this is what integrity is. This is what dignity is. This is what perseverance. You understand me? Every juror in here is related to an officer in this county. The fact that I have a lawsuit pending against this judge right now and the federal district judge, and they still forcing me to sit in front of a jury that's not my peers, it's completely illegal. It's completely overstepping the Constitution. 3 of the jurors had close relations to Mike Laird by their own admission. One of the jurors was related to the guy that arrested me, to the officer that arrested me and broke my phone and destroyed my evidence. That I had, the same officer that I had to prove set me up in front of me at the last trial of a jury that voted in my favor 11-1. Nobody in this country would have voted in my favor. That juror that voted against me was planned, was tampered with. I'm still in prison.
Tension reaches another level as the defendant begins challenging the judge more directly. After receiving warnings about contempt, he argues that his character has already been damaged during the trial and attempts to object to the jury itself. He then accuses several jurors of having ties to law enforcement and claims the panel cannot possibly be impartial. Rather than discussing the evidence, the courtroom becomes consumed by arguments over fairness and alleged bias.
For pointing a gun at somebody. Pointing a gun, which is a misdemeanor. I didn't shoot the gun. I just pointed. By law, that is a misdemeanor. They charged me with aggravated assault. I was the sole provider in my household, and we was eating good. You understand me? My probation officer, the detective went to talk to my probation officer, trying to see what he can figure out how to violate my probation. You know what my probation officer told him on the paperwork? He's been in compliance for the past 3 years. But they hate me so much. The last 3 trials, this man had a white prosecutor. DA Michael Laird, his prosecutors was white. Miss Angela Mann, been his prosecutor. Angela Mann Nealon, been his prosecutor for a while now. I've never seen nobody else working with him except Angela Mann and Waylon G. Thompson, both which are white. But here he is on this trial, he got a black woman working with him to try to defeat the appearance of racism. Like I'm not gonna acknowledge that. And then it was somebody in the jury box that was related to her. She probably don't even want to be here. Y'all probably gave her some ridiculous offer. 3 years ago, I filed a subpoena, and y'all clerks were telling me on this case, filed a subpoena on this case. And y'all clerks sitting up here telling me that I can't file a subpoena, that they can't subpoena nobody for me because they can't do it for me.
That's not an accurate statement.
That is very.
I'm sorry.
I can tell you what day it was.
Sorry, sir.
I can tell you what day it was.
Once again, I'm going to tell you when I speak, you must stop, please. That's the rule of law. I know you don't like to follow these things, but that's the rule of law. Subpoenas, if you send subpoenas, first of all, I urge you, have an attorney to help you.
I don't need you.
I know.
I'm a jurist. I'm an expert.
The subpoenas you've submitted are inaccurate, incorrect, and weren't properly filed. That is why they were not submitted. And I urge you, get some help so you can do it properly. That's why, sir. And not everybody can. That's why people go to law school and become.
The defendant should have compulsory process and obtaining witness.
As long as it's done correctly.
I don't need a paper motion if I ask you on record in the court to do so.
All right. Go to what is relevant That's enough on that. Go to what's relevant of the allegation of the first-degree felony of aggravated assault.
Everything is connected. Y'all only did.
Is there anything else you want to add?
Y'all would have never charged me with this.
Is there anything else you want to add?
If I never filed a habeas corpus, I filed a habeas corpus accusing Joshua Hall, Detective Duchamp, who else? Detective Duchamp, Joshua Hall, Mike Laird, my attorney, of conspiring against me, right? I accused them in a habeas corpus back in 2022, March 9th. Ever since then, I ain't been getting no sleep because y'all want to keep sending people after me in the jailhouse to harass me. And you keep talking about they keeping me in isolation because of my behavior. I was in TDC. I had a job in TDC, doing good. But as soon as I filed a lawsuit, y'all transfer me back down here, throw me directly in isolation. And you trying to talk about my behavior. No, y'all don't have me in isolation because of my behavior. You have me in isolation because of these lawsuits. Matter of fact, I'm about to show the world. You want me to stop? You don't want me to show the world? Hit that button and electrocute me right now.
Sir.
Hit that button and electrocute me right now because the world.
Sir, why don't you act properly, sir?
Oh, I'm acting very properly.
I don't believe anyone in this room thinks that, sir.
I'm pretty sure they don't because they all get picked.
No, sir. We're talking about common decency now, sir. The law allows you to speak, but be decent.
Peoples versus
Please.
Greg Abbott. Now let me show y'all whose name is on the front for it. Whenever you sue a judge or the DA or a prosecutor, anytime you sue a government.
Sir, once again, you're charged with aggravated assault. Stay within the bounds. It is not relevant.
Depending on this too, in the federal court right now, that y'all real messed up about.
Sir, this is an allegation of striking somebody about the head and body. Stay within that allegation.
I'm supposed to be sitting in this court. I'm supposed to be dealing with this in the Supreme Court because my habeas corpus is pending in the Supreme Court right now.
Anything else?
Because of this charge.
Is there anything else you want to add?
Retaliation through conspiracy, right?
Is there anything else you want to add?
I'm going to continue.
How long do you expect for this to go on?
It's going to take all day.
No, it won't, sir. If it's not going to be relevant to the facts, I will stop this now.
Well, go ahead.
To the facts of the charging instrument, sir.
Do your thing.
Then it ends now. That is enough. It is not relevant anymore.
Retaliation.
That is the end.
Everything I'm talking about.
Is there anything else you want to add about the allegations?
Corporate in the Supreme Court. Now, I sent an emergency motion. Let them know what y'all keep doing and how y'all keep harassing. That Lieutenant Tinker body cam played yesterday.
Instead of returning to the assault allegation, the defendant shifts into a series of accusations involving previous convictions, prosecutors, court staff, and even jail officials. He claims retaliation, racial bias, mishandled subpoenas, and punishment for filing lawsuits, insisting these events explain why he's standing trial today. The judge continues trying to redirect him toward the actual charge, but the testimony grows increasingly emotional as the defendant claims he's been deliberately targeted for years.
He admitted that he refused to feed me, and he thought that was okay. I wasn't aware of it. So, Federal Statute 18 U.S.C. never cause or induce any person to withhold testimony or other object from an official proceeding shall not be imprisoned more than 20 years.
All right, hold on. Again, that is not relevant to this case at all. This is a state jurisdiction case, not a United States jurisdiction. There's the federal government. It has its own sets of rules, ladies and gentlemen. I was a United States attorney for 20 years. And this is state law that we're dealing with here. Distinct laws. Distinct law.
Focus on.
Sir, let me complete the instruction of law to the jury. Please, once again, for the 100th time, don't interrupt when the court's given the law. Thank you. That is not relevant to what the charge is in this case. This is a state jurisdiction case with its own elements. We're not trying a federal crime right here in this court.
If two or more conspire to injure, oppress, or intimidate any person in any state on account of any right or for exercising the same, shall not be imprisoned.
What are you reading from, sir?
This is federal statute.
That is, once again, its own set of rules. This is not what we are. We're not a federal
18
court.
USC.
I know. 20 years I dealt with that.
Why do y'all hate me so much?
Anything else you want to add, sir?
5 months after I filed a lawsuit on a judge for refusing to issue the writ of my habeas corpus, after my attorney admitted to refusing to give me the search warrants, why is Lieutenant Ford all of a sudden coming harassing me like I did something to him? Why? I hated that man because he kept on squirting waste in my tail because I wasn't selling him a pack of cookies. Levine won't clean out my cell, man. Can you please make Levine clean out my cell and let me go in and take a shower? Or look, matter of fact, just give me some of that bleach and give me a towel and I'll clean out my cell. Man, I ain't trying to die, man. This Corona was serious. It was 2022. Corona was serious, still serious. You know what he did? You need to stop arguing with people. You need to stop arguing with people, grievous, man. Wave his hand. Walk off. My heart must have dropped. So you gonna leave me in this? You gonna leave me sitting in another man's waist? Explain to me when I take you to your isolation tip. What? You gonna put me in isolation for dashing an inmate? You ain't trying to do no talking, cuff up, or I'm coming there and get you. What? Really? You ain't gonna clean up this waste, but you gonna come in here? Oh, you gonna come in here to hurt me, but you ain't gonna clean up. All right. Come on, let's fight me. Because I'm not cuffing up. Now, I'm not about to cuff up for you to hurt. Now, I cuff up for you to clean this white cell out, and then you can write me up if you want me to. If you want.
The disagreement now centers on federal law versus state law. The defendant repeatedly quotes federal statutes, believing they prove his rights have been violated, while the judge carefully explains that this trial concerns a state criminal charge governed by different legal standards. Even after multiple explanations, the defendant returns a complaint about jail conditions and prior legal disputes, leaving the judge with little choice but to finally excuse the jury and address the ongoing disruptions.
To block my privileges, but you're not about to come in here and put me in an isolation cell after refusing to clean out this net. Run down on me after I get done dashing him with the water, not waste. Being in another man's waist, I was throwing up. So I can't touch my own. Listen, this day I didn't swing at nobody. I didn't threaten to stab nobody. You know what I'm saying? You give me to the isolation cell. I had all my paperwork, all my legal work, my legal books, my kids' pictures I would never give in. He threw all my shit. Threw all my stuff away. And I said, this is my 4th trial. I came in here plenty of time. They ain't never searched me coming back from court. They searched me going to court, but they never searched me coming back from court because there's no need to. Made me strip out butt naked, squat and cough while the cameras was going. And they stood a distance so the camera could see my whole body. I'm asking them, what is this? Somebody told y'all to record this so they can have some fun afterwards? Why have y'all got y'all recorders on? They got their heads turned like they don't want to see me. Somebody had to send them to do that. The habeas corpus is that thing that Donald Trump wants so much to abolish because of situations like this.
No, I'm sorry, sir. You're misleading the jury. Habeas corpus, he is getting his time at trial. He wants his time at trial under the Constitution. That is his habeas corpus hearing right here.
At my probation hearing, when you said based on the scientific...
No, sir. We're not getting into the probation hearing, sir. I'm sorry.
I sentenced you to 20 years.
All right. That you keep interrupting the court. You will be placed outside.
I was talking.
We're going to have right now the jury is going to be excused. You were speaking about something that had nothing to do with this trial, sir. The next time you interrupt, you will be placed in a holding cell. We will have the trial for you to listen to. That's the way the rules say it happens when you keep interfering with the rules of decorum. We're in short recess.
I'd like to continue, Your Honor. I'd like to request to continue.
No, that's denied. We're going to complete this trial.
I have wrote a complaint on the federal judge about allowing Judge Stevens to keep me in prison. 3 weeks later, he had me bench warrant out here, threw me directly into an isolation cell, blocked my communication about 5 months. And the whole time, Lieutenant Ford would cut my water on periodically, and I would have to argue and trip out about it just to get it cut back on. That complaint was on the judge for him refusing to rule on my habeas corpus.
Wait, hold on. So the jury is clear. Are you saying that I ordered sanctions against you in the jail? Is that what you're telling this jury? Is that what you're telling this jury, sir? Under oath.
I'm telling the jury that Lieutenant Ford is able to be doing the stuff that he's doing to me the past 12 months because I wrote a complaint on the federal judge for refusing to rule on my habeas corpus, which was complaining on you. And 2 days later, he ruled on it, but I was bench warrant out here. He ruled on it July 16, 2025.
The federal, you're telling the jury that the federal judge denied the relief you were requesting, correct?
Right. And
Okay.
he bench warrant me out here.
All right.
I mean,
Move forward.
that's the only way I can be bench warrant out here. I wasn't in the isolation cell. I had been in TC for like almost 2 years. But as soon as I filed a lawsuit,
With the jury temporarily removed, the judge becomes much more direct. He questions whether the defendant is accusing court itself of participating in retaliation against him, giving him every opportunity to clarify his statements. Rather than backing away, the defendant doubles down on his allegations involving lawsuits, isolation, and jail officials. The exchange becomes one of the most intense moments of the entire trial before the proceedings move into closing arguments.
a few months before, in a complaint, a few weeks before, I get bench warrant out here.
But there comes a time when we got to look and say, you know, all this stuff that he's been doing, he's already done in appellate courts and everything else, and they've all denied him. And so he's just he doesn't get his way. And so he keeps saying it over and over, just like he did with the lieutenant, hoping he'll get a tray. And I get tired of it because what he did that day on June 6th of 2023 was a violent act. And you cannot deny that, because if you deny it, then you have to say, I don't recognize the fact that he wrapped his hands in cloth, getting ready for battle with pins in them, and came out of that cell with his mattress out in front of him. Why did he wrap his hands with cloth and put pins in them? And why was he coming out of the cell with those if he wasn't intending to harm anyone? Second, you heard Lieutenant Ford say in his testimony that when Mr. Peoples reached for his face, lunged at him, which you've heard a couple of them say, lunged at him with his hands, he still had those pins in his hands and all he felt was pain. And yes, there's some scratches on there, but you also see that little sharp one, and that's where Otis Anderson saw, standing right next to where Lieutenant Ford was struggling with this man, who all he had to do was say, I'll go down to the other cell. And he had a chance with Mr. Darby up here on the stand. You remember Mr. Darby walked all the way down to that cell and stuck his head in there, was in there for 30, 40 seconds looking around. And he did not come back and say, yeah, you're right. Because he could have asked him that while he was on the stand. And none of that ever happened. Darby said he went down there and looked, and the cell was fine. And all the officers went down there with him afterwards and said the cell was fine. So all that stuff he's doing is just a smoke screen, just like it was for that when he threw himself on the ground because he didn't get a tray. He doesn't get his way, and so he starts just doing anything he can to try to get his way. It's all about Mr. Peoples. Everybody's out to get Mr. Peoples. The appellate court's out to get Mr. Peoples. The judge is out to get Mr. Peoples. I'm out to get Mr. Peoples. I even have some influence with the Supreme Court of the United States and the Court of Criminal Appeals. I don't know where that comes from because I've never even been to the Supreme Court or the Court of Criminal Appeals, but evidently I have influence there. I've wrongfully indicted him, wrongfully convicted him. He's doing 20 years in prison for something that he shouldn't have done. and he won't even accept responsibility for that, even though he knows he pled guilty to it. And you do not have to agree on whether you think he did it intentionally or knowingly or recklessly. Some of you can think he did it intentionally. Some of you can think he did it knowingly, knowing he might cause injuries. And some of you can think he did it recklessly by the fact that he did it, because all that is an aggravated assault, and it's against a public servant who's doing a lawful duty. That cell was being decommissioned. You've heard them all say it. They have to follow certain standards. They were decommissioning that cell. They had to do some work on it to make it safe for them. And then you get back to, why do you have to do stuff on cells? Because, even introduced it in here, people get out of their cells to attempt to escape. It does nothing but cause them misery, heartache. You heard them. They all have dealt with him. Even Lieutenant Tinker, bless his heart, you can see him trying to be nice and just come on down and get in your cell. And what's he doing? Grabbing the cell, holding on, arguing, and then he starts yelling those words. And I want y'all to remember those words he was yelling from inside that cell. I'm going to kill. Now, I'm not going to repeat the N-word that he used.
Why not?
Don't.
That was being yelled out by this man in that cell. Why would you yell that out over a stupid tray that came from Tuesday on a Sunday, and you don't get your Tuesday tray on Sunday? They don't do that. And the lieutenant ended up giving in to him and giving him a tray. It just rewards him. So I'm asking you, when you go back here, you look at this, it's apparent from the injuries on Lieutenant Ford. And I'm not going to harp on them. Those are sharp instruments coming down, and it didn't come down because he was trying to distract him. He was trying to get him in the eye, guys. He's trying to poke him in the eye, and he missed. That's why it came down here, and it's down here all the way down, because he was swinging. So don't feel sorry for him. You should feel sorry for Lieutenant Ford, who has to go through that every day with this man. Go ahead, let him go. If you want him to do this again and just keep on doing this, let him go. Feel sorry for him. Or you can say, you know what, enough's enough. You don't rule this world. You don't get to rule the jail. You don't get to rule this day, and you don't get to rule this court. Hold him responsible. Find him guilty, and then let's get on to the next part, and you can do what you need to do there. Thank you.
The defendant shall rise, please. In cause number 23, CR 727, we, the jury, find the defendant guilty.
Now the prosecutor takes over and completely changes the tone of the courtroom. Instead of responding to conspiracy claims, the focus shifts back to the physical evidence and witness testimony surrounding the alleged assault. The prosecutor argues that the defendant's repeated accusations are simply distractions designed to avoid responsibility, and urges the jury to focus only on the actions that took place during the incident, leading directly to the jury's decision.
Of the offense of aggravated assault against the public servant as charged in the indictment, signed by the jury foreperson. Present your argument to the jury.
Wait, my wife.
All right. You're doing that voluntarily and because that's what you want.
That's what I want.
Oh, then the state may go forward.
He's right. He was placed on probation, I'll just do it this way. He was placed on probation. I said, if you'll own up to this and you behave yourself, you can get out of this without a conviction. You get probation for 10 years. And if you're really good, you can get off probation without a conviction. He couldn't follow the rules, and that seems to be a pattern with Mr. Peoples. Because he doesn't want to follow rules. He wants to control everybody. That's what he wants to do.
Because you said
Sir,
wants to
sir,
control everybody.
I'm sorry. Hold it.
So,
Sir, you cannot make outbursts. You gave up your opportunity to make a final argument. He has a right under the law without interruption to make his final argument. So please follow the rules, sir. Go ahead.
he cannot follow rules. And the problem is with this is that it's kind of funny when he does it in here, but when he does it in a jail setting where there's weapons or he's got things that he can hurt people with, or where he throws feces on them or does things to them to just totally make everybody's life miserable. Plus he's got other inmates that he's throwing things on. He's trying to escape. He's doing all these different things. It's not funny. He's facing 15 to life and it's serious. And yet he's still here making all these comments because to him, it's just a game. Everything is a game. It's because he was serving a 20-year sentence when he did this, and evidently that doesn't scare him one little bit. He's asked you all ago, he told you just go ahead and give me a life to send me home, and that's up to you. But I'm asking, that's what it is. I'm sorry,
Sir, the second time I've had to scold you on making outbursts during a time that he is not to be interrupted by law, just like you were not to be interrupted if you wanted to make your closing argument. Please follow the rules.
And it makes me sad that an individual can't just do what he's asked to do. You realize who he is, because you had already convicted you.
Sir, this is the third time during the final argument you have interrupted the attorney.
I'm just going to ask you to give him a really good bump up from 20 years because of the fact that he was serving 20 when he did this. And that doesn't seem to affect him. Make sure that he understands that he's not in control. He's not in control.
For the record, that's the fourth time that the defendant has defied the court's order and has interrupted the prosecution who is giving his final closing, which the law says he can do without interruptions, unless you want to make a legal objection.
That was a legal objection.
That was not, sir.
Objection. For point of gun,
Proceed.
30 years to life.
Sir, follow your foreperson into the jury deliberation room. We will await your verdict. And alternates, thank you for hanging in there with us.
And y'all feed up the man sleep at night.
Sir, you're going to have to muffle him. He can't be speaking to the jury as they're leaving like that. That's improper. That is all. We're in recess. We're in recess.
What else can you do wrong? What else can you do? How else can you do it? Keep your isolation for another 12 months?
He's going to handle his own appeal.
Oh, is he really? Oh yeah, that's
He's got like 3 writs pending here. I think he's got 2 pending. He's filed stuff with the Supreme Court. He's filed stuff with the Court of Criminal Appeals.
The jury delivers its verdict, finding the defendant guilty of aggravated assault against a public servant. Even after the verdict, the courtroom remains tense as the prosecutor argues for a severe punishment, pointing to the defendant's repeated refusal to follow rules. Throughout the sentencing phase, the judge repeatedly has to stop interruptions, reinforcing that courtroom procedure applies equally to everyone regardless of the outcome.
All denied everything he's done, but he keeps filing. Yeah. They call him the serial filer.
The defendant shall rise. In cause number, the defendant is refusing to rise, for the record. In cause number 23 CR 727, the state of Texas versus Raymond Peoples, we the jury, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. Signed by the jury foreperson.
Judge, it's pretty clear that this person Mr. Peoples was serving a 20-year sentence and was still under the custody of the Texas Department of Criminal Justice, so it's mandatory to be stacked. We'd ask that you stack it on top of this prior sentence.
You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. And that sentence of 40 years shall commence immediately on the completion of the sentence. For 3 years. You're going to have to stop him from speaking so we can complete this. As obstreperous as he'd been through the whole trial, he continues to interrupt the court. And thus, this sentences shall run cumulative or consecutively to each other by law. You are now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. That is all. And please note that the defendant was shouting over the court as he is being led out, as the court is trying to read the formal sentencing and a judgment as provided by law, more leeway than the court has given to any other defendant out of the court's history of 616 jury trials in this courtroom. But nonetheless, the defendant to the very end acted obstreperous and defiant of the rulings and orders of the court.
The trial comes to its dramatic conclusion as the jury sentences a defendant to 40 years in prison to be served consecutively with his existing sentence. Even during the formal sentencing, he continues interrupting and speaking over the judge, prompting the court to note that his defiant behavior never stopped from beginning a trial until the very end. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next video.